Okay, my phone. Do I Zoom? Yeah, let's see the door. Yes, yeah, this works. Yes, I'll just tap when you have 5 minutes or when it's like about 2 times. Yeah. You okay? Hi, Mr. Dea. May I know how do we address you as?
Okay, wait. So do you all have a Mr. President or what usually?
Single? For single person, usually we call them by their title. So, I mean, since you're not a professor, then would you like us to prefer us to address you as Mr. President or Mr. Dialan?
Ooh, so it's really up to the person, is it, for y'all?
Really up to the arbitrator, so whether what they prefer.
Okay. Just Mr. Dayalan is fine.
So they're okay. Good evening, Mr. Dallin. Thank you very much for your time. Before I begin, I will be addressing some housekeeping matters, and I would like to mention that the speaking order which we follow is appellant 1 and appellant 2, followed by a respondent 1 and respondent 2. Then for appellant 1 is me, Mark Max Repeater, and appellant 2 is Mr. Austin Seah, my co-counsel. Then Mr. Brandon and Mr. Ramesh will be taking over, covering the issues from the respondent's point of view. We will be speaking for 10 minutes and reserving 1 minute for rebuttal. Now,
You'll each be speaking for 10 minutes or 10
we
minutes?
each will be speaking for 10 minutes, and
Okay.
cumulatively, we will be reserving 1 minute for rebuttal.
1 minute per person or 1 minute per side?
1 minute per team. So
Okay.
1 minute per side.
Understand.
Thank you. So may I begin?
Yes.
Good evening, Mr. Dayalan, members of the panel. My name is Mark. Together with my co-counsel, Mr. Austin Seah, we represent the appellant, Mr. Antonio Fortuna. I will address issue A, the admissibility of email, and issue B, the lawfulness of refusal to surrender the mobile phone. My co-counsel will then address the remainder of the issues. Mr. President, my submission on admissibility proceeds in 3 short steps. First, I will explain when the appeal began to run and why it ran from the receipt of the motivated decision and not from an earlier unreasoned confirmation. Second, I will show you the CS jurisdiction was validly seized and why it runs from the receipt of the motivated decision and not admissibility. And third, if the panel considers the appeal to have received late, I will submit that the reinstatement is warranted because the delay was attributable to the client's counsel and not the athlete himself. And the appellant acted promptly in good faith. Now, Mr. President, Mr. Dayalan, I will begin with the concession. We accept that the statement of appeal was received late by the CS court office. We do not dispute that fact. However, the concession does not end at an inquiry because the appeal runs from the receipt of the motivated decision and the delay is attributable to the counsel and not just athlete. At Exhibit 7, we see, may I direct Mr. Dayalan to Exhibit 7 of the SAM hypothetical?
May I have the page number?
The page number is 40, paragraph 26. Oh, sorry. So, yeah, 26. So at paragraph 26, sorry, Mr. Dayalan, it's page 5 of the PDF. So the FIFA Appeal Committee decision was upheld on 31st March 2026, but it was communicated with grounds only on the 2nd April 2026, which is evident from Exhibit 7 of the hypo. The distinction matters because without reasons, the appellant cannot meaningfully assess whether what to appeal. And the CS has consistently recognized this principle in the 2018 case of Ivan Bilardo. The panel at paragraph 75 and 76 mentioned that the appeal only begins from once the reasoned decision has been communicated, because without the reasoned decision, the right of appeal cannot be exercised efficiently. Now, applying the logic here, motivated decision was received on the 2nd April 2026, and the statement of appeal was filed on the 23rd April 2026. Now, the appellant acted within the current framework. Now, if I may take Mr. Dallin to paragraph 27 to 31 of the record. At paragraph 27, the statement of appeal was filed and the filing fees was paid. At paragraph 29, the CS informed the counsel that the appeal had not been received. And at paragraph,
What's the time limit for filing an appeal? And where can that be found?
Mr. Dallin, the time limit is reflected on Article 50, subsection 1 of the FIFA statute.
And it is
It is 21 days.
21 days. So this would be exactly 21 days.
Yes, Mr. Dallin. So now, critically, there's nothing in the record which states that it was a fault from the athlete, but rather fault from his counsel, because there was a virus which was infecting the counsel's computer and the law firm. So on Mr. Fortuna, he instructed the counsel in time, paid the filing fee, and acted promptly and transparently. The CS jurisprudence distinguishes between jurisdiction seizing acts and procedural defects. And in the 2019 case of Christina Iowa and International Weightlifting Federation, the panel held at paragraph 66 that the jurisdiction is seized by the statement of appeal, and that the defects later in the procedural steps does not automatically render the whole appeal inadmissible. Now,
so in the FIFA statute 50, subsection 1, it says appeals against final decisions by FIFA in its body shall be lodged within 21 days of receipt of the decision.
Yes,
so I'm totally with you that the start date of that time is 2nd April when the decision was published. But can I ask, what does it mean shall be lodged? Is it sufficient that the appeal was sent by your client, or must it be acknowledged? What exactly does shall be lodged mean? Because I think that really gets to the heart of this time limit matter, right?
Mr. Dallin, we are trying to imply here that the appeal was sent out by our client, and the interpretation of the word lodged means that it has to be sent by the client and by the office itself. It was only later on found out that there was a virus which had infected the lawyer's law office, and due to that very reason, the appeal wasn't able to go out of the systems of the law firm itself.
I understand, but do you have any authority for that interpretation of the word lodged? Because it is a bit ambiguous. So maybe that.
Certainly, Mr. Dallin, I understand your question, but I will not be able to assist you on authority at this point in time. Mr. Dallin, now I understand. Moving on to the second issue, which is the mobile phone. My submission on the mobile phone also proceeds in 3 steps. First, I will clarify the proper framing of the issue, and this case is not about refusal to cooperate in principle, but rather proportionality of demanding an unrestricted access to the whole mobile phone itself. Second, I will submit that such demands constitutes a disappropriate inference with private life, and particularly where there are no safeguards, limits, or alternatives were even considered by FIFA. And lastly, I will explain the existence of parallel criminal proceedings. Now, the proper framing is not whether athletes must cooperate in principle, but rather the issue is whether FIFA is entitled to demand an unrestricted access to athletes' entire life, which is his phone. And while the parallel investigations are going on his father and him, our submission is that the refusal was lawful primarily under Article 8 and supported by under Article 6 of the ECHR. Now, the mobile phone is not a single document itself. It is a whole diary of an individual. It's a comprehensive record of individuals' private life, communications, and even relationships. Now, if I may direct Mr. Dallin to paragraph 20 of the record, it says over there that FIFA demanded appellant's entire mobile phone. And then they also mentioned that if you were to not comply at paragraph 21, they warned him of sanctions and repeated the demand again on paragraph 22, despite the appellant having obtained legal advice from his counsel at paragraph 23. What we are trying to imply here is that that there was no safeguards, there was no filtering, no limitation of scope, no temporal restrictions, and no independent oversight. The European Court of Human Rights made it clear that such access engages Article 8. In the Exciologo case, at paragraph 51, the telephone communications fall within the private life and correspondence. And at paragraph 54 of that very case, it is said that the use in disciplinary proceedings without safeguards violate Article 8 of the ECHR. Now,
Why does the ECHR apply here?
Mr. Dallin, the ECHR applies over here because the CAS code draws a lot of inference from the Swiss law itself. And the CAS laws, which is the CAS, has been influenced by the Swiss law itself. Thus, the ECHR firmly applies over here. Now, I understand that my time has elapsed and I only have 1 minute left. May I have an extension of another 1 more minute to sum up my whole submission?
Certainly.
Thank you very much. So now the parallel proceedings, which in the parallel proceedings issue it was disappropriately aggravated and the existence of parallel proceedings. Now, if I may direct Mr. Dallin to paragraph 13 of the record and Exhibit 5. It was said on the 4th November 2025, Iridonian public prosecutors launched a criminal investigations into the appellant's father and appellant for sports manipulation. The investigation remains going on according to para 24. Now we understand that FIFA had been very comfortable with the idea of sharing earlier information with the Iridonian public prosecutors. And I understand that my opposing counsel will put forward an argument that FIFA promised that they will not share the documentation or any other evidence which may influence the proceedings. But FIFA has already done that in the past. So it is impossible for us to even trust FIFA at this point. Now, Mr. President, I would like to highlight that this blanket of refusal to cooperate, this was not a blanket of refusal to cooperate, but rather we are trying to imply that if FIFA were to request for us for a specific WhatsApp message or a specific amount of evidence, we would be gladly able to share. But they are requesting for a whole phone, which we are putting forward the argument that is disproportionate. Now, these very reasons, we respectfully ask the panel to find that the appeal is admissible and alternatively that the red line to be reinstated. And second, the refusal to surrender the phone was lawful and should not have been sanctioned. Now, unless if I can assist Mr. Dallin any further, I will now hand my time over to my co-counsel, Mr. Austin Seah. Thank you.
Good evening, Mr. Dallin. As earlier introduced by my co-counsel, Mr. Mark Maxwell Peter, I am Austin Seah, and I'll be addressing the remaining 2 issues on appeal. Now, turning to the third issue, we submit that the anonymous email and the witness statement must be excluded or given no weight because they fail every care safeguard regarding anonymous evidence. And I make 3 arguments in that respect. Firstly, CARE's jurisprudence applies strict conditions with respect to anonymous evidence. Secondly, these conditions were not met by either the witness statement or the email. And lastly, CAS jurisprudence also rejects unauthenticated digital evidence. Now, turning to the first argument, in the 2019 CAS decision of Karimudin and FIFA, the panel held that anonymous testimony is only admissible if three conditions are met. Firstly, there must be good reason for non-attendance of the witness. Secondly, the evidence in itself is not sole or decisive. And lastly, there are counterbalancing factors that safeguard the fair reliability of assessment. And it is prudent to note that a respondent must succeed on these three elements, while the appellant merely has to disprove one. And in this respect, we contest the first and third element. Now, turning to the third element, if I may first direct Mr. Dialan's attention to PDF page 32, paragraph 6, regarding the anonymous witness statement itself.
Okay.
The witness claims that they fear intimidation because there are rumors that Mr. Fortuna's father has criminal connections. And this is distinct from the 2019 CAS decision of Karimudin, where there was an objective third-party affirmation of a real risk, as shown by a co-witness being granted asylum, which is a protective status which, generally speaking, is only granted to individuals who demonstrate a legitimate fear of persecution or threat or danger. And here, as noted by my co-counsel, there are only ongoing undecided criminal proceedings as confirmed by Exhibit 5 against the appellant's father, and this falls short of the threshold as seen in Karimudin. Now, counsel for the appellant may choose to argue that as long as there's a potential risk, it suffices to meet this threshold. However, it is crucial to note that when we analyze whether there is a risk, it is to be done objectively. And the 2018 CAS decision of Samir Arab at UEFA noted that fear is a subjective emotion. In our case, the fact that a witness is relying on double hearsay to claim a potential risk clearly falls foul of clearly is an unsubstantiated subjective fear that does not meet the objective threshold of real risk. And
You
now,
said earlier that there are standards for anonymous witness statements. Can you bring me to those standards?
the standards are located in the 2019 CAS decision of Karimudin, Mr. Dialan.
Okay, no, you were referring to I think was it the FIFA statute or the CAS? There is provisions for anonymous witness statements.
Oh no, apologies, Mr. Dialan. In that respect, I was referring to only the CAS decision of Karimudin. The
Oh,
CAS code itself is silent on admission of anonymous evidence.
I see. Understand.
And now turning to the third element, which is precisely what the appellant's case turns on, the 2009 CAS decision of F.K. Pobera ruled that evidence that cannot be cross-examined meaningfully because context is missing cannot satisfy the standard of proof. And now we understand that the witness is fearful of the appellant's father. This is precisely why the panel in the 2018 CAS decision of K.S. Skanderbru and the 2019 CAS decision of Syed Ali Reza, which affirmed Karimudin, confirms that audio-visual protection is not merely a factor, but a strict condition in place for cross-examining anonymous witnesses. This is to ensure that there's a balance between the procedural rights of the accused and the necessity to protect the safety of the witness themselves. And therefore, audio-visual protection is not a mere factor, but a strict condition that serves this precise purpose, which is precisely why multiple CAS panels have upheld this as a strict factor. And in our case, there are no offers made by FIFA on this decision. As the CAS panel has the power to assess the merits of the case as provided by R57 of the CAS Code, we submit that this panel should cross-examine the witnesses through the aforementioned safeguards. And without such safeguards, the panel should not be admitting the witness statements or the email.
How much leeway does CAS have in disturbing findings of fact on an appeal from FIFA? Because from what I can understand, the anonymous statements were admitted by FIFA, and their disciplinary code has provision for anonymous participants. So how far can CAS disturb these findings of fact?
Actually, Mr. Dialan, CAS has a wide discretion in disturbing these findings because R57 of the CAS Code explicitly allows the CAS to conduct a de novo hearing which is to reassess the merits of the case based on any evidence that can be subsequently adduced by the counsels to therefore establish the merits. And now turning to the anonymous email, it is even weaker because it's unauthenticated digital hearsay. Now, the email itself alleges that Mr. Fortuna's father received 50,000 dodgy coin, but that in nowhere in the email does it show any ties to the appellant's father himself. It merely states the syndicate, and even the fact that the sender said, "Look, the crook," does not mean that so and so received the messages. And this was noted to be a critical factor in determining whether a screenshot of any digital evidence can be admitted in a 2019 case of Karamuddin. Now, I note my time, and unless there are any further questions on the third issue.
No, go ahead.
Thank you. I'll now move on to the fourth issue on match manipulation. Now, on the fourth issue, the respondent may attempt to draw a fact barrage and tie loose connections between the various strands of evidence in the record to establish a violation of Article 20. But the factor which the respondent's case turns on is whether there's direct or indirect link between the appellant and the scheme itself, to which the answer is no. Therefore, the appellant submits that Article 20 of the FIFA Disciplinary Code has not been violated for three reasons. Firstly, the threshold of comfortable satisfaction has not been met. And secondly, even if the anonymous email is admitted, this threshold is still not met. And lastly, the betting report does not prove the evidentiary link required to provide guilt or conspiracy. Now,
Wait, so are you saying that you do concede that there has been a match fixing scheme?
We do agree that there's a match fixing scheme based on the fact it's due to the anomalous betting patterns. But as noted in the case of Scanderbrew, the decisive factor for manipulation to be tied to the appellant is that there's a direct link, and based on the facts, there is not. So to raise the case of Oleg Oryakov that also dealt with match manipulation, in that case, sanctioning bodies relied on a strong convergence of evidence, such as intercepted calls, financial flows, cross-examined witness statements, and in some cases, even finding of state courts. Now, the threshold of comfortable satisfaction is not that of a mere balance of probabilities. In fact, it exists between a mere balance of probabilities and the threshold of beyond reasonable doubt. In Pobeda, it is crucially noted that mere witness statements or poor performance cannot meet this threshold. There needs to be strong evidence showing the involvement of the accused. And presently, we have only one strand of evidence that could possibly tie the accused to his father, which is that contemporaneous phone call. Even if we take the respondent's case to the highest, such that we assume that the appellant's father had indeed threatened the appellant to conspire, on the facts, the appellant said, "No, I will not go along with you in everything," showing a refusal rather than an agreement. And therefore, we submit that the threshold of comfortable satisfaction has not been met with regard to direct or indirect relations.
I have two questions for you. So first, that you said that the evidence that they are putting forth to say that your client violated Article 20, is it?
Yes.
Is insufficient. So first, why are you trying so hard to make inadmissible the anonymous email and anonymous witness statement? And second, you said that the contemporaneous phone call itself is ambiguous, and this goes to your co-counsel submissions. Wouldn't that be made easier by actually giving access to your client's phone and seeing what exactly was the content of that conversation, and if there are any contemporaneous messages which can help the investigation?
Certainly, Mr. Dalan, and I will answer your question in two parts. Unfortunately, I note that my time has elapsed. If I may
Please take your time to answer the question.
Thank you, Mr. Dalan. So, with regards to the first question, we are not stating that the anonymous email or witness statement should be admitted. In fact, we are countering that they should not be admitted in our case because they fail every single care safeguard with regards to submitting evidence. And regards to
No, but my question was why are you trying so hard to make them inadmissible? Because you just said that what they show is actually not enough to prove that your client violated Article 20, which is really the crux of what you're going for, isn't it? So isn't it fine to just admit them if it's insufficient, according to you?
Understand, Mr. Dialan. So in this respect, we have to distinguish between proving a case and respecting the safeguards that's been provided under the ECHR. So similar to the US Constitution on pleading the fifth, it's similar to our case because the appellant is merely invoking a right to ensure that his right to privacy or his privilege against self-incrimination is not violated. And this is contrasted with proving the case, as notably the burden of proof falls on the respondent who is trying to make out a claim of match manipulation. Rather, it's the appellant's job to ensure that the rights of our client are respected. In regards to the content of the phone, it goes towards the same idea of respecting the appellant's fundamental rights under the ECHR. We do not, with regards to submitting the mobile phone, we do not submit that the appellant should not cooperate in full. Rather, if FIFA had put in safeguards to ensure that the mobile phone was analyzed properly and that evidence that they extracted from the mobile phone didn't intrude into the appellant's private life, we would have agreed. But based on the facts, what FIFA requested for was the entire phone, and therefore the appellant feels justified in invoking Article 8 to ensure that his right isn't diminished. And now turning to the second submission, if I may have 1 minute to wrap up on this point.
Please do.
Thank you, Mr. Dylan. So we note that the remaining pieces of evidence, even if it's admitted by this court, is the anonymous email itself. And now we do note that the email claims that there is potentially a financial link where there was a transfer of money. Well, this is similar to the case of O and UEFA, where there was a clear plan by the referee to pay a bribe of euro 50,000, which evidence showing that the appellant and the conspirators were planning how to avoid custom taxes. Well, in our case, the respondent has not proven any nexus between the $50,000 dodgy coin transfer to the father's wallet and the appellant's actions. In Pobera, the panel was reluctant to rely on isolated claims of money transfers that could not be verified by the examining persons involved. And notably, in that exhibit itself, there's no evidence that the appellant knew of any dodgy coin transfer. There's no evidence that the appellant received any money, and there's no evidence that the appellant actually agreed to help his father. And therefore, as the appellant's case turns on whether there's a direct link or an indirect link, we submit that both cases, there was no direct or indirect link tying the appellant to match manipulation, even if we agree that there was betting anomalies. And unless I may be of further assistance on the last issue.
No, thank you.
Thank you.
Thank you.
I think next time when you all do the Zoom thing also, right, make sure you put the correct names. Because right now it says Mark and Brandon. So just for future. Because that's what.
Could I just check if I am audible and visible?
Yes.
Okay. Good evening, Mr. Arbitrator. My name is Ramesh Kanna and I represent the respondent, FIFA, together with my co-counsel, Mr. Brandon Zhang. I will spend 10 minutes on the first two issues, followed by Mr. Brandon on the last two issues, and we respectfully reserve 1 minute for our rebuttals. Now, Mr. Arbitrator, the case that confronts you today requires you to take a stance on the sliding scale between procedural justice and substantive fairness. Now, in the vast majority of cases, the stance to be taken has already been cemented through the CAS Code and through the ECHR. However, we do acknowledge that in extremely unique circumstances, exceptions can be made. And our position today is that the case that confronts us now does not fall within one of those exceptions. In this regard, I make two submissions. Firstly, the statement of appeal is inadmissible. And secondly, the refusal to hand over his phone was unlawful by Mr. Antonio Fortuna. Now, with regard to the first issue, I understand that opposing counsel spent a fair bit of time explaining when the 21-day window period occurs. Now, this to the respondent is a non-issue. We do agree that the filing was attempted within the 21-day window. However, the bigger issue is the fact that it was not received by the CAS office. And I note that Mr. Arbitrator earlier had questioned opposing counsel, what exactly does shall be lodged mean? Now, if we take reference to R31 of the CAS code, shall be lodged means that the electronic filings have to be received by the CAS office. Now, what is critical here is that it was not received. And this fact is uncontested by opposing counsel. Thus, the statement of appeal was indeed filed late. Is Mr. Arbitrator with me?
Yes, just looking at Rule 31. Go on.
Thus, the heart of the contention for this issue is whether reinstatement as a remedy should be allowed. Now, with regard to reinstatement is in itself a remedy that is extremely debatable, given that cases such as the 2016 SFT case of claimant and FIFA have clearly stated that reinstatement should not be allowed because procedural formalities exist for the protection of equal treatment. Moreover, the 2019 CAS decision of PFC and UEFA.
Sorry, if I'm reading Rule 31 of the CAS code correctly, this actually pertains to notifications and communications that CAS or the panel intend for the parties. This does not refer to communications made by parties to the CAS office, unless you can show me otherwise. So in fact, the interpretation of shall be lodged is actually still a live issue here. So can you point me to some authority that would support your proposition for what shall be lodged means? Because as far as I can see, all a party can do when sending a request for arbitration, or in this case, an appeal, is actually send the thing. And they did have technical difficulties. I don't think you are disputing that. So that really goes to the heart of this issue, doesn't it?
Understand, Mr. Arbitrator, I understand your concern. And if we look at CAS jurisprudence, there's a CAS decision, Christina, Iowa, which faced a similar situation when email filing had not been received by the CAS office due to a technical failure. And in that case as well, the same principle was recognized in that electronic filings of the statement of appeal are only considered to have been lodged and received when they enter the sphere of control of the recipient, that is the CAS office. And to answer the second part of your question, this is not the heart of the contention because the opposing counsel themselves agree and concede that it was not sent within time. However, what is being disputed is whether the remedy of reinstatement should be allowed. An opposing counsel relies on the case of 2024 FC Football Club and Galatasaray, where reinstatement was indeed recognized. Now, I've given you two authorities which state that reinstatement should not be recognized. Our purpose in stating this is not to pitch our case so high as to say that reinstatement should not be allowed at all, but rather to say that reinstatement is in itself heavily disputed and should only be allowed, if at all, for the most exceptional circumstances. And in the case that opposing counsel themselves rely on, there's a two-element test that has to be met for reinstatement to be allowed. And these two elements are, firstly, the instance of disorder must not have been caused by any fault on the appellant counsel's part. And secondly, the request for reinstatement must be made promptly. Now, if we look at the no fault requirement, the threshold for the no fault requirement falls on whether preventive measures could have been taken. And if we look at the case of Christina, Iowa, there was a technical failure. However, the panel rejected reinstatement because the technical failure had occurred due to an expired security certificate, which could have been renewed. It was a preventable error. Now, I understand that the panel might find issue with the fact that our case is distinguishable in that here there's a third-party actor that's causing a cyber attack. However, we're not saying that the cyber attack could have been prevented. Instead, what could have been prevented is a simple due diligence check of seeing if the message had been delivered by checking the sent items folder would have revealed that the email had indeed not been sent. Or any error message that would have been delivered when the email was not sent would have been enough to give the council foresight into the fact that there was an error.
How
However,
do you know that looking at the sent items folder would show that it had not been sent? Because usually in a lot of email servers, when there's some sort of corruption and you can't send out the email, you will actually get back a notification like in Outlook, oh, it can't be sent for whatever reason. So what gives you the basis to say that they should have checked their sent items folder or something like that? It could have actually shown up there, but this was due to a cyber attack, wasn't it?
I understand the concern, Mr. Arbitrator, and in that regard, this is the highest that we will take the case. We understand that that's a fair concern. However, this is not fatal to my case because the promptness requirement has not been met. You see, the IT service provider had told them that there was a potential for the email to not have been sent on the 26th of April. However, they only made an attempt to even ask CAS if they had received the email on the 28th, which was 2 days after. Now, the requirement for promptness, as stated in the case that opposing counsel himself relies on, is that the reinstatement request must be made immediately. Here, there's a 2-day delay, which is unnecessary given that a simple call would have sufficed. Even if we were to assume their highest position that the cyber attack was not resolved by the 26th. Now, if Mr. Arbitrator has no further questions, I would like to move on to the second issue.
Well,
Now, opposing counsel's argument under the second issue stands on two grounds. Firstly, Article 6 of the ECHR, and secondly, Article 8 of the ECHR. Now, I note Mr. Arbitrator had questioned earlier, why does the ECHR apply here? And to this, opposing counsel responded that this panel is seated in Switzerland, and given that Switzerland is a member of the convention, it applies. However, the critical question here is whether the convention applies to FIFA. Because you see, within FIFA's regulations, the fact that these regulations apply to the appellant is akin to a commercial contract of employment between FIFA and the appellant. So within this particular contract, the Swiss Federal Tribunal nor the CAS panel has any autonomy to change the bargain of the parties. And now if we were to look at the specific article, Article 12 of the FDC, which gives FIFA the power to request for information, it states that persons subject to this code shall help to establish and or clarify facts, in particular, shall provide any evidence requested. Now, the fact is simple. The employment contract that the appellant had signed up for states that the FDC is what is applicable, and in the FDC, any evidence requested has to be provided. Nevertheless, even if this panel is to assume that the ECHR applies, we would argue that the thresholds for Article 8 and Article 6 have not been met. Firstly, for Article 6, the right against self-incrimination, for this right to become applicable, there must be a clear and imminent danger that the evidence collected within this particular proceeding would be passed on to the public prosecutors in Iridonia. And here we would say that that is not the case. Now, I understand that opposing counsel has argued that the anonymous email was sent over to the Iridonian public prosecutor and that this exhibits imminent danger. However, the anonymous email would not fall within the ambit of evidence that is to be kept confidential by FIFA. If we refer to Article, I understand that my time has elapsed, Mr. Arbitrator. Could I request for an extra 2 minutes to sum up
Sure.
options? Now, if we refer to Article R34 of the FIFA Disciplinary Code, the confidentiality article, is Mr. Arbitrator with me?
Yes.
Here it states that all information that has been disclosed during the duty of the disciplinary committee shall not be sent out. So in this case, the anonymous evidence was not disclosed by Mr. Antonio. Thus, for Mr. Antonio to look at this particular sending of the email and deciding that there's imminent danger for him to not send his phone is legally flawed. Thus, we would argue that the threshold for clear and imminent danger was not met. And we find support for this from the case of Jerome Valque, where a similar situation of parallel criminal proceedings also occurred. And there they stated that if there is no collaboration between the public prosecutor and the disciplinary committee, then the standard of the clear imminent danger would not be met.
I
Now,
think another friend also alluded to his right to privacy and all that. So, and yes, that goes somewhere. And I understand Article 12 of the FIFA Disciplinary Code. But usually, when you are asking for something like a phone, which contains a lot of information about a person, there usually has to be some basis for that. So, did you all have a basis? Did FIFA have a basis for actually requesting that phone? Such as there's evidence in there that they couldn't obtain any other way.
yes, Mr. Arbitrator, this goes to the heart of the contention of the issue because this falls on Article 8's protections on rights to privacy, and this has been discussed in a precedent case where they had stated that the request for information has to be proportionate to the need for information. Now, if we look at the present case, there is inculpatory evidence against the appellant through the witness statement. The witness statement observes that there was a heated conversation between the appellant and his father, where it seems that the father was pressuring the appellant to do something the night before the match. Now, this taken together with other evidence, other pieces of evidence, leads to the inference that the appellant is guilty of match fixing. However, the appellant denies that the conversation with his father was of this nature. Yet he does not provide any form of counter evidence that is exculpatory. Thus, in this regard, if we had access to his phone and we could see the communications that he had with his father, we could potentially provide justice to the fact-finding process. Yet here the appellant refuses to provide evidence on his own accord and also disrupts the fact-finding process, which is why we argue that Article 8 does not come into play either. With that, I conclude my submissions if I may be of no further assistance.
Oh, thank you.
Good evening, Mr. Dayan. My name is Brandon Zhang. As introduced earlier, I appear for the appellant, the respondent, FIFA. I will make two main submissions. First, that the anonymous witness statement and anonymous email is admissible. And second, the appellant has violated Article 20 of the FIFA's disciplinary code. Mr. Dayan, it cannot be a coincidence that the betting fraud system was alerted, that there was poor performance, poor goalkeeping in the match, that the anonymous statements were received, that there were evidence of crypto transactions, WhatsApp communications to an organized crime, and criminal proceedings initiated by the Iridonia's public prosecutor's office. Under sports jurisprudence and recognized by this tribunal, these pieces of evidence in totality can be inferred at the sole discretion of the panel to find the appellant guilty of match fixing. In the 2009 CAS, the 2009 Court of Sport, hereby referred to as CAS, decision of FK Poveda versus UEFA at paragraph 52, and in the 2018 CAS decision of Emmanuel Bariffa versus UEFA at paragraph 101, the panel held there was match fixing on the totality of the evidence. And in the latter case, the panel did not have the benefit of hearing any direct evidence from persons with direct knowledge, and there was no witnesses called by parties to testify, and the panel in that case relied solely on the documents provided. And in the present case, we submit that there is good reason to admit the evidence. First, the client, if I may request Mr. Dayan to turn with me to the PDF page 32 at paragraph 6. Starting at the second line here, I quote, "There are rumors Mr. Fortuna has friends involved with criminal organizations. I hear these organizations follow the snitches get stitches rule. Now, Mr. Dayan, we understand this is speculation and could be rumors. We understand and we acknowledge this. However, there are 10 players on this team, and they have been identified by name in Exhibit 1 PDF, page 14, at the very bottom of the page. And it cannot be said that the criminal organization is not involved, because frequently in these types of cases, they are involved and pose a real risk. And in the 2011 European Court of Human Rights case of Al-Khawaja and Tahiri versus the United Kingdom, at paragraph 123, I quote, when a witness's fear is attributable to the defendant or those acting on his behalf, it is appropriate to allow the evidence of that witness to be introduced without the need for cross-examination by the defendant or his representative, or for the need to go live, to go and produce the live evidence, even if such evidence even if such evidence was the sole decisive evidence against the defendant.
I
Now,
have two questions for you. Earlier, your learned friend was talking about the standard required for such fear, which is subjective, that it needs to have at least some third-party cooperation, but here there is speculation. So how do you answer that? And second, even if we take it that yes, he was okay to be afraid, it's fine that we understand that fear. Why is he so comfortable identifying himself as a player of the men's football team? Because as you yourself said, there's about 10 players that have already been identified, and based on the content of the statement, it would be pretty easy for any criminal organization to narrow him down.
Mr. Dayan, there is currently enough evidence in order to start criminal proceedings, and this poses a real risk. And moreover, there's a threat here also. This is speculation, but there is quite the danger of facing retaliation and also being outcasted and labeled a snitch. And this could be detrimental to the athlete's career. And here on the facts, the evidence is not decisive or sole. There are other evidence on the record. Now, with respect to appellant's argument on counterbalancing factors, in the Karamuddin versus FIFA case raised by appellant, the panel found that the evidence to be reliable because the statements were coherent, acknowledged their limitations, and avoid exaggeration. Presently, this is exactly the case. The witness recalls specific phone call the night before the match. The witness does not speculate and acknowledges that he did not hear what the father was saying. And therefore, the evidence is internally consistent and corroborated with the other evidence on the record, and thus the burden shifts to the appellant to prove otherwise. And we submit the evidence should be admissible. Unless there are no further questions, I will turn to submission 2.
I just have one. What is the prejudice to your client actually if we decide not to admit these anonymous statements, the statement in the email?
Well, thank you. We submit that even if the panel does not admit the evidence, we can still make out a claim for match fixing. There are other evidence such as the betting report, performance analysis, social media news, the WhatsApp message connecting the appellant's father to the crypto transactions, as was indicated by the phone call, and the fact that there are betting that 12 hours prior to the match, there was an increase in betting for the team against the team when it was reported by analysis that they had an 83% chance to win.
So what you're saying is your client is okay if we don't admit these anonymous statements anymore.
We submit yes. However, we do ask the panel to admit the evidence.
Okay, you can continue. And I'll give you, similar to your co-counsel, about 3 extra minutes.
Thank you. Just one last point, Mr. Dalian. If the evidence is not admitted, we also submit that it would prejudice my client to a fair trial hearing as well.
I see.
Thank you.
Okay.
Turning to the last submission here. We submit that the appellant is guilty of match fixing under Article 20 of the FDC. In the 2018 cast decision of KS Sken Deburu versus UEFA, at paragraph 198, the panel held there was match fixing when the panel assessed the totality of the evidence. This included the betting reports, performance analysis, market operator excluding the bets from the live markets, and the panel found it was consistent with reaction from media news and the international perception of opponent players, supporters, and betting operators. In the present case, if I may ask Mr. Dayan to turn with me to page PDF 11.
Okay, I'm here.
Here at the tab where it says rating, you will see it indicates red. And
Yes.
yes, so this indicated that there was a strong betting fraud that was occurring. And at PDF page 13,
Okay. Yeah.
at minute 22, the markets were suspended. And here the operators stopped because they realized that there was potential fraud. And if I may now, if Mr. Dalian can turn with me to page 15, and this is the performance section of the evidence. Here at minute 21, Mr. Fortuna attempted a lofted pass. The height was misjudged and headed interception before rolling the ball into an empty net. And at the next page, 16, at minute 5:54, the ball was allowed to pass through Fortuna's hand despite being well positioned. And at minute 44, Fortuna took an extra unnecessary touch, but the goal was saved. Mr. Dayan, these suspicious plays are well below the standard of play for a professional athlete. It cannot be said to be simple, poor performance.
Isn't there evidence that he was sick that day? Is it contested?
We understand that he may be sick. However, being sick and still playing does not excuse a player from falling below what is called the acceptable standard. There's poor performance, and then there's unreasonable performance that cannot be explained. For example, when the ball was allowed to pass right through the hands despite Fortuna being well positioned. And therefore, the panel in the two cases that I had cited, in the KS Skenbaru versus UEFA and the Pobeda versus FIFA case, the panel assessed the totality of the evidence and found that there was match fixing and imputed the guilt to the client. And in the present case, we submit that on the totality of Exhibit 1, 2, 3, 4, and 5, there has been match fixing. And on the last point, the respondent submits that the prosecutor's office, that Mr. Appellant's father had provided his wallet to the public prosecutor's office. And we submit that anybody can submit a crypto wallet after taking out the funds. And on the record, there's a WhatsApp message showing that he received $50,000. Now, all these factors taken together cannot simply be a coincidence. And the tribunal in the previous two cases has made out match fixing, and therefore we submit that there has been a violation of match fixing under Article 20. Unless I may be
I think the fact that there has been match fixing is not really in contention. I think there's more than enough to show that. But what I think you have to show is that Mr. Fortuna, I believe the felon is actually the one connected to it, or at the heart of it, or integral part of it. And I don't really think you have done that. Maybe you can assist me a bit more on that before you go.
Thank you. Before the night before the match, the appellant was on the phone with his father. And this is a crucial piece of evidence because 12 hours prior to the game, all the betting reports came to show that there had been an increase in betting. Now, we understand that he refused to cooperate and that he couldn't go along with his father. However, this piece of evidence is taken out of context. It doesn't mean that the father asked him to cooperate. There may have been other people involved on the facts. And if his father did ask him to participate in match fixing, he simply could have just changed his mind a few hours later and then did it anyways. But we don't know what was on that phone call. But on the totality of the evidence, we submit that the connections and the evidence before the panel is sufficient to give rise to a breach.
But the burden is on you to actually prove that he was involved with the match fixing. And even if we take that anonymous statement as part of the evidence, it really doesn't show anything. It just shows that he had an argument with his dad, and he himself admitted he had a generally contentious relationship with his father.
Yes, Mr. Dayan. However, we submit that there has been players who played poorly that did not rise to the level of that did not play to the standard of a professional football player. And this led to the 3 goals that was scored. And these are also crucial evidence. And the fact that the betting analysis showed that they had a chance to win 83%, and the team that they lost against was Kanna. And Kanna was in the bottom ranking of the league with only 1 win to 12 losses. So,
Okay.
Thank you. This concludes my submissions.
Thank you.
Before I begin, can I confirm that I am audible and visible, Mr. Dial?
Yes, you are.
Thank you. Mr. Dialan, respondent's submission centered around the fact that the appellant himself was instrumental in making this match manipulation claim. However, it was actually possible for the appellant to both manipulate the match and not deprive his team the opportunity to qualify. If I may now turn Mr. Dialan's attention to PDF page 11, second paragraph of the Genius report.
Okay.
Iridonia only needed a draw to qualify directly or significantly with a loss of a goal difference of 2 or less to earn a playoff spot. Ultimately, the match ended 0-3, meaning that Iridonia was completely eliminated. Therefore, if Mr. Fortuna was as instrumental in manipulating the match as the appellant claims, he would have logically aimed to concede the game by only 1 or 2 goals, and this would have satisfied the betting markets, which only required Iridonia to lose, while still preserving his country's historic opportunity to reach the World Cup. And playing so poorly that he missed the playoffs entirely suggests a genuine sporting failure, rather than a calculated criminal conspiracy. And unless I may be of further assistance to the panel, this
you.
concludes my submissions. Thank you.
Thank you.
Mr. Daya, just one point in rebuttal, in Sir rebuttal. Here, Exhibit 5 and Exhibit 4. This is the anonymous email, which showed that there's a crypto that informed of a $50,000 crypto transaction. And Exhibit 4 shows the WhatsApp message of the syndicate. And here, Mr. Luck Fortuna text message says, just received the last part of the coin. And this was at 3:02 p.m., the very day of the match, 4 hours before the game. And therefore, we submit that all of this evidence in totality proves that the appellant is guilty of match fixing.
Okay.
Thank you.
Can we?
We can just go out and listen to him.
Yeah, yeah. Can we stop the recording now?